Dr. S. Rajendra Babu, Sri T. Venkataswamy, Srimati Rajendra Babu. Her name is Asha, but I know her. And friends.
You can't forget because your daughter-in-law's name is also.
I and on my own behalf, on behalf of the Gokhale Institute of Public Affairs and the Indian Liberal Group Bangalore chapter, extend a hearty welcome to the two distinguished dignitaries occupying the dais and all those present in this hall. Dr. Justice Rajendra Babu was born on 1/6/1939 at Bangalore as the eldest son of Sri R. Sanjeevulu, a distinguished judicial officer of the erstwhile Mysore and then the new Karnataka, who last occupied the post of Secretary to Government, Law and Parliamentary Affairs, Government of Karnataka with great distinction. Dr. Rajendra Babu, on securing a first class in the intermediate science, went to hibernation to dabble in spirituality for some years and returned to the household in 1962. He then studied law in Karnataka University, securing the very first rank, and then enrolled himself as an advocate in 1965. He then joined the chambers of Sri S. Venkatramaya, one of the then leading advocates of Bangalore, who was closely associated with the management of Gokhale Institute of Public Affairs till his elevation as a judge of the Karnataka High Court. He also happens to be my mentor. Dr. Rajendra Babu, with his keen intellect and almost unrivaled advocacy, made his mark in the profession and was chosen as counsel for both central and state governments. Even with his busy practice, he was the editor-in-chief of the Karnataka Law Journal. He was appointed as a permanent judge of the Karnataka High Court on 19/2/1988 and a judge of the Supreme Court on 25/9/1997 and retired as Chief Justice of India on 1/6/2004. After his retirement as Chief Justice of India, his services were utilized as Chairman of the National Human Rights Commission. On laying down that office, he has returned and has settled down in Bangalore, pursuing his academic career as Chair Professor from 2004 in National Law School of India, University, Bangalore, guiding doctoral and postdoctoral students. As a judge of the High Court and Supreme Court, he has rendered many landmark judgments. Sri T. Venkataswamy was born on 17/11/1923 at Alur of the erstwhile Bellary district. On completing his BA/BL from the Madras University, he enrolled as an advocate of the erstwhile Mysore High Court and practiced law in Bangalore till 1/1/1952. He was appointed as a Munsif in the erstwhile Mysore state from 2/1/1952. By his honest and hard work, he secured all the promotions legitimately due to him and retired as district judge. On his retirement as district judge, he was appointed as the Secretary General of the Karnataka Legislature and served the full term of that office. Lastly, he was appointed as Chairman of the Second Backward Classes Commission and has submitted his monumental report to the government. Sri Venkataswamy has been closely associated with the management of the Gokhale Institute of Public Affairs for more than a decade and is even now guiding the institution with a distinction. With these few words, I request Sri T. Venkataswamy to preside over the function and conduct the proceedings. Thank you.
Good evening, ladies and gentlemen. President of today's deliberations, Mr. Venkateswamy, Mr. Justice Puttaswamy, Mr. Justice Shailendra Kumar, Mr. Shailendra Kumar, and ladies and gentlemen. I am thankful to the Indian Liberal Group and Gokhale Institute of Public Affairs for having given me this opportunity to share some of my thoughts on the contribution of Supreme Court in the development of democracy. Indeed, I have known Justice Puttaswamy for nearly 45 years, and I have known Mr. Venkateswamy from my childhood, even from the college days I have known him. So far as Justice Puttaswamy is concerned, he has been very close to me, and I have appeared before him as a lawyer. Indeed, I can recall one or two instances where he has written his judgments on the arguments addressed by me. In fact, in a turf club matter, the opening sentence he used was, "Horse racing is the king of sports and sport of kings." This is the style in which he used to write. He looks very simple, but if he sits down to write something, it will be really very interesting. He can use racy language. He can be very clear in his thought, and he was systematic in disposal of the matters. That was what I appreciated most in him. I tried to emulate him, but I do not know how far I have been successful. So far as Mr. Venkateswamy is concerned, he is an upright judge, upright man, of whom I have great regard. In fact, if I am here today, it is at the instance of these two elders, and I have great respect and regard for both of them. Mr. Justice Puttaswamy, this is the second occasion he has asked me to address a gathering. That is, on an earlier occasion I had to address in a university when he asked me to speak on a subject chosen by him. It was on the emerging trends of intellectual property. It was at that time I was still a judge of the Supreme Court. In fact, in spite of my onerous duties, I had to spend quite a good deal of time to pour over books and also develop my thoughts on the particular subject. So far as Mr. Venkateswamy is concerned, he has been a colleague of my father, and therefore I have the same regard I have for him as I have for my father. In the presence of these two gentlemen, I do not know how to address you, particularly on the subject of democracy and Supreme Court. The subject was chosen by me in a particular thought passing in my mind. Pandit Jawaharlal Nehru, while addressing in the Constituent Assembly, stated that while we want this Constitution to be as solid and as permanent a structure as we can make it, there is no permanence in Constitution. This was what he said. The tension inherent in the desire to achieve radical social and political changes while preserving the Constitution was recognized by Nehru, which was sustained even in the 20th century. A debate started at the start of the 21st century, focusing on the paradox to ensure constitutional fixity while allowing for possibility of change. This tension has two significant developments in Indian constitutional law: the prospect of radical constitutional change and the contrary surrounding judicial activism. The NDA government in 2000 constituted a national commission to review the working of the Constitution, but this attempt was subsequently abandoned due to lack of political support. The basic structure doctrine expounded in Keshavanand Bharati in 1973 places substantive and procedural limits on the amending process provided in the Constitution. This leads us to the criticism of scope of Indian judicial review by the Supreme Court. Broad interpretation of fundamental rights, relaxation of rules as to standing, resulting in adjudication of wide-ranging issues which was not appropriate at an earlier times. The court has armed itself of wide-ranging remedies and continually supervises the implementation through committees regulating diverse fields of activity. Scope of judicial review has extended to include scrutiny of constitutional amendments, executive proclamations of national and state emergencies, executive policy framing processes, and legislative inaction affecting core interests of citizens. However, the contours of judicial activism are blurred. Basic structure review is a distinct form of constitutional review and is independent of judicial review. The formulation and practice of basic structure determines mediators between two values, democracy and constitutionalism. Indian experience with representative democracy during last 6 decades has recorded crucial shifts in public policies owing to electoral verdicts, ongoing emphasis on social reform laws, strengthening of process of the fair election and extension of democracy to Panchayat Raj institutions, retention of basic features of democracy except during emergency between 1975 and 1977 in a vast nation ridden by serious problems has helped course of planned social change. Judicial instances on free and fair election, corrupt-free franchise, transparency through compulsory declaration of candidates about the assets and antecedents, supplemented by election commission, which has grown into a strong institution. Thus, democracy is firmly rooted in India. I can give one example as to what happened. When Mrs. Gandhi was in power, she changed the symbol of her party on 3 occasions. Under the Representation of People's Act, if there is a change insofar as symbol is concerned, it becomes as good as changing the party itself. If 3 parties she changed and all the 3 parties were elected to power, she came to power. But when she misbehaved with the imposition of emergency and certain atrocities committed in the name of emergency, she was thrown out of power. Later on, when the other government came to power, other party came to power, when they did not behave well, they were thrown out and Mrs. Gandhi was brought back again to power. When she came back to power, she thought she had commanded the majority in the whole country, she was able to muster it. Particularly in the state of Tamil Nadu, she thought she can get the good majority of the parliamentarians. But unfortunately, what happened to her was when she dismissed MGR's government and imposed president's rule and thereafter called for election. In the election, the representatives elected to the state assembly were all belonged to, most majority of them belonged to the DMK party. Thus, to the state assembly, the representatives elected were of one party. To the parliament, the persons who were elected were of a different party. This clearly indicates that though Indian populace in general is not so literate, but they are politically conscious and they have been able to change the governments whenever they want and appropriately elect their representatives. That capacity Indians have. In addition to that, there was one government in Kerala, leftist government. In West Bengal, there was a leftist government, while in Maharashtra, there was a government headed by Shiv Sena party. It's a very fundamentalist party. And in the center, there was a Congress party ruling. The hues and colors. See, in the whole country, this constitution allows such a mixture of different parties coming to power and ruling. And that is possible only in a strong democracy. If there is no strong democracy, it is not possible to have different parties in power and they can rule or put forth different viewpoints. From this point of view, I would like to address you on 4 or 5 decisions of the Supreme Court which have strengthened the values in democracy. That is the particular endeavor which I have taken to do today. Before doing it, I would just trace in the last 60 years how the Supreme Court has behaved, particularly in discharge of their duties. The superior authority of the court over all governments, legislatures and tribunals is derived from the supreme will of the people as expressed in the Constitution. This is the source of legal authority. Its moral authority over the people is by contemporary public opinion. The court is adored, condemned, or ignored from time to time in accordance with the role it chooses to play in the life of the community. The court has always acted with the spirit of time on the basis of values and norms that it has set for itself. The mood of the country, the prevailing economic situation, the dominating ideas amongst the people governs the activities of the court during any particular period. The values that the court seeks to uphold shifts and turns from the period to period due to pull and push of such forces, and the court appreciates the requirement of the society. The understanding of the nature of these forces and the perspective which mounts the vision of such requirements depend upon the philosophies of individual judges who at any point of time constitute the court. After all, judges' personality is a funnel through which the value norms enter judgment. Out of such a welter, during different periods, perceptible trends and major policies of court emerge. The court has always sought to be major center of political power in the interest of the society. Supreme Court is after all a political institution. The executive is its real rival. If the court found a liberal and enlightened executive irremovably occupied the center, it tried to share power with the executive. If the executive was aggressive and bellicose, the court stepped aside. If the willing executive moved away from the center, it sought to occupy the seat of power itself. If it could not do any of these, it created its own field of operation. Vicissitudes in the fortune of successive executives perpetually made court readjust its position. The history of the court shows that during its decade in the opening, 1950 to 1960, finding itself in Nehruvian era of economic progress, political stability and nascent optimism in the country, the court led by 4 erudite Chief Justices, Shastri, Mahajan, Mukherjee and Das, functioned with commendable dexterity. While seemingly maintaining the balance of power among the 3 wings of the state, the court gradually and cautiously extended its own authority. It laid the foundation for future activities of the court. The court moved forward and backward and ultimately drew a line. The court blended the orthodox judicial function with policy making. It tried to protect the rights to property, particularly of the rural landowning class, from the clutches of legislation. During the second decade, 1961 to 1970, finding a crippled economy, instability of political authority, immorality in public life, unbridled exercise of plenary power of constitutional amendment, the court led by Chief Justice Subrao, Hidayatullah and Shah went into policy making on a grand scale. It curbed the power of parliament, struck down major economic decisions and overruled public policies of government. It acquired a judicial sovereignty. It appeared as though in India there existed government by judiciary. In this decade, it leaned in favor of urban, commercial, middle class protecting their economic and political interest. During the succeeding period from 1971 to 75, when Mrs. Gandhi's government, supported by public opinion, reiterated against the court usurpation of political and economic power by constitutional amendments, the court fought back with its back to the wall under the collective leadership of Chief Justice Sikri and Justice Hegde and Shelat. The court in the long run could not stand united and firm. The court was divided, the people were baffled, and the judiciary was injured. Then came the emergency from 1975 to 1977, with the executive assuming aggressive postures, when under Chief Justices Ray and Beg, the court gave way and abdicated its part of judicial review, though it delivered a magnificent judgment in Mrs. Gandhi's election case. During those few tumultuous years, the court occupied zero existential space in the Indian society. Thereafter, during the tenure of the Janata government, 1977 to 1980, it bounced with vengeance against the emergency and the massive public support. The court, under the leadership of Chief Justice Chandrachud, endorsed the policy decision of the new government. The political atmosphere was relaxed. The new executive was liberal in finding the atmosphere. The court tried to retrieve lost judicial territory. It extended its jurisdiction and acquired immense power of administration. The court became the most powerful judiciary in the world. It extended the meaning of state, prescribed limits to executive discretion, and redefined the scope of judicial interference, which was in fact unbounded and limitless. The court and executive shared the glory of this brief but significant period in the history of the country. These were the court's finest years. Ms. Gandhi returned to power in 1980. The embarrassed court did not interfere with the new economic measures of political decisions. The court directed its attention to the causes of poor, the oppressed, and the submerged. It shifted the focus of judicial activity to public interest litigation in championing the causes of tenants, workers, employees, and prisoners in the name of socialism, rule of law, and constitutional conscience. A new subsidiary class had emerged on the Indian scene with politically and socially inspired patrons, and legally assisted, it became a loud and effective pressure group with a wide constituency. The court chose to listen to the new class. It provided a springboard for public interest litigation. Within the bounds of economy, the court could afford marginal egalitarianism and a small dose of socialism. In the hands of 5 judges, Justice Krishnayar, Bhagavati, Desai, Chinnappa Reddy, and Thakkar, who had constituted a fraternity, a new judicial activities were pursued with missionary zeal and crusading vigor. In applying new jurisprudence, they had scant regard for the existing procedure and precedents. They became activistic and dynamic. Some of the other brother judges did not share their views. The open commitments of judges to one or the other social philosophy caused anxiety amongst litigants. This known judicial philosophy eroded the image of the collectiveness and impartiality of judiciary at the apex. Then came 1985, which year saw great significance. With a new government at the center, the court too had a new leadership in Chief Justice Bhagavati. Bhagavati, during the preceding 12 years, had done all he could to expand the judicial power of the court, to enlarge its constituency, made the court a meaningful and relevant institution for the benefit of the masses. Now he was confronted with still larger problem, the survival of the judicial system itself. The court assumed a gestalt perception and had adopted a holistic perspective towards the administration of law and justice in the country. Apparently, the court behaved like a partner to the government, lending cooperation in wider fields, chastising whenever it should, and protect whenever possible. It openly and categorically set its goal, implementing social justice, which is primary and essential function of an enlightened executive. It showed the highway and abandoned the byways for achieving its objectives. During the period at the beginning of 2007, India witnessed 18 chief justices and 8 prime ministers, fragmented political parties, unholy alliances among politicians, bureaucrats, and criminals, massive public issues relating to corruption and pollution in gigantic proportions appeared as legal issues before court. The economic situation, which had deteriorated fast since 1980, was taking a different shape in 1991 with a change in policy of liberalization, privatization, and globalization. The future perspectives were looked down with trepidation by many. The collapse of the Berlin Wall symbolized the collapse of USSR and socialism. The only option left for mankind was to abide by the market forces. There were a number of scams, a demolition of the masjid, large-scale caste violence, highly explosive public issues appeared before court as legal questions. The first half of this period did not have any particular doctrine or any specific cause or any particular direction. The court functioned collectively and effectively, responding to all the challenges. The second part of the last decade witnessed a new significant phenomenon, momentous in its dimensions, the explosive role of the media. It had the impact on the judiciary and democracy itself. The court responded to the spirit of time and chose to accept the evidence proposed by the media, which inflicted new strokes on the Indian psyche. The courage to take all, the boldness to put on social events, the devoted pursuit of greatness crowned the court with glittering glory during this eventful period. The legislature, the executive, and the judiciary are the 3 coordinates of the state and are bound by the constitution. The ministers who represent the executive, the elected candidates who represent the central or state legislature, and the judges of the Supreme Court or High Court who represent the judiciary have all taken oath prescribed by the 3rd schedule of the Constitution. They swear to bear true faith and allegiance to the Constitution. All the 3 wings of the state have to function in complete harmony. A decision of the court either disapproves or approves a decision of the legislature or of the executive. In either case, the court neither approves nor condemns any legislative or executive policy, or is it concerned with the wisdom or expediency. The concern of the court is to determine whether the legislation is in conformity or contrary to the Constitution, and quite often has to examine the rationality of the statute. Similarly, when the court strikes down an executive action or order, it is not the spirit of confrontation or to assert its superiority, but in discharge of its constitutional obligation, and acts as a judicial watchdog. In interpreting the law, the court is required to keep particular situation in view, and so as to provide a solution to the problem to the extent possible. This is the legitimate exercise of judiciary in discharge of the obligation under the Constitution. The gaps in the existing law, which are filled up by updating the law, result in evolution of juristic principles, and in due course of time get incorporated in the law of the land, thereby promoting its growth. Judicial review is a basic feature of the Indian Constitution. Every state action has to be tested on the anvil of rule of law, and that exercise is performed when occasion arises by reason of a doubt raised in that behalf of the court. The function of the court is to administer justice, and in discharge of that duty has to respond to the aspirations of the people, because the people of the country in no uncertain terms have committed themselves to secure justice, social, economic and political, besides equality and dignity to all. The court has given a very expansive meaning to Article 14 of the Constitution, and thereby every action of the executive can be tested as to its reasonableness. The concept of equality has been understood as the antithesis of arbitrariness. The expansive meaning given to Article 21 in respect of expression of life and liberty has covered wide variety of problems in the society. The court has included in the term of right to life as meaning not mere animal existence, but includes the right to live with human dignity and all that goes along with it, namely the bare necessaries of life, such as adequate nutrition, clothing and shelter, and facilities for reading, writing and expressing in diverse forms, freely moving with fellow human beings. This principle was further extended to include protection of health and strength of workers, prevention of abuse of children, opportunity and facilities to children to develop in a healthy manner and in a condition of human dignity, education facilities, just and humane conditions of work and maternity relief. At one stage, it included even the right to livelihood. The questions relating to euthanasia were raised before the court. It has considered cases for relief against effects of radiation on employees, leakage of toxic oleum gas from a chemical plant, appalling conditions in a home for destitute women, remand homes and observation for children, right of a prisoner to write and publish a book, relief against solitary confinement of a prisoner, relief against pollution and protection of environment, and relief against telephone tapping, economic empowerment through distributive justice for the poor, Dalits and tribes is an integral part of the right to live. Equality of status and dignity for bonded laborers have to be identified and released and rehabilitated in terms of Articles 21, read with Article 39, 41 and 42. Women have right to work with dignity and without sexual harassment. The court, following international conventions, formulated several principles to prevent this problem. It held that for residents of hilly areas, access to road itself is life. The concept of liberty is of widest amplitude. It covers a wide variety of rights which goes to constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. I will not elaborate this particular aspect, I will leave it at that, although I have set down in my written speech. So, right to privacy also came up in several cases. Justice Subrao and Justice Jeevan Reddy held the right to privacy is implicit in Article 21. Thus, this right is the right to be left alone. This aspect was examined in the context of surveillance and maintenance of history sheet. Unique identity number may affect privacy and human dignity issues. Possibly, if a password on online transaction is stolen, the same may be replaced, but if identity of man himself is lost or replaced, the question is how to redeem the situation. In the case of HIV positive patient, certain steps were taken by the court. I have elaborated it. I will not detail that. Judicial activism arises when executive fails to perform its duty as envisaged under the Constitution or the law, the duty of the court is given to give an alarm to the sleeping executive or blow the whistle when it plays foul. One of the most important decisions of the Supreme Court in the recent times is the one in relation to the upholding of direction issued by the Election Commission while filing nomination papers by prospective candidates. In fact, the Right to Information Act itself was developed on the basis of this particular development of law. Originally, the idea came from the Shedgars Union in Rajasthan when they went on a dharna to bring out certain material which was in the possession of the panchayats, which namely the manner in which they had spent the funds that had been provided to them. It is the whole exercise in relation to right to information started with that particular movement. The right to information has now resulted in an enactment, but it is not the act that gives the right. It is the Constitution itself which gives that particular right, which was recognized in the particular case. The court, though it had held on earlier occasions that the right to vote, to contest an election, challenge an election in court are all statutory in nature, due significance was not given to Article 326 of the Constitution. The said article provides for elections to the House of People and to the Legislative Assembly of the states on the basis of adult suffrage. Thereby, the court recognized the constitutional right to vote to every adult in the country, of course, subject to the law made by the Parliament. As long as an adult satisfied the provisions relating to Representation of People's Act as regards qualifications of a voter, he has a right to vote, thus attaining the constitutional right to vote. Such a right, when exercised, becomes a kind of expression made in favor of a candidate or not preferring a candidate, which is in fact protected under Article 19(1)(a) of the Constitution, which guarantees fundamental right to freedom of expression. The concomitant right of expression includes the right to information. Thus, the right to vote, when exercised, becomes a right to freedom of expression, thereby the necessary information regarding the candidate contesting an election to his criminal past. If such information is not available, the voter cannot appropriately exercise his right. Support given to the directions of the Election Commission was thus jurisdically explained. This is when advance of the value in democracy, this particular development has taken place. The court has exercised many powers in relation to environmental protection. I will not go into the details of that. And the most important decision of the Supreme Court so far has been in the Keshwanand Bharati's case. The scope of amendments to the Constitution had been considered in Shankari Prasad versus Union of India, Sajjan Singh versus State of Rajasthan, and Golaknath versus State of Punjab. In the first two decisions, amendments to the Constitution affecting the fundamental rights were upheld, while in the last of the said decisions, it was held by a majority that it is not permissible to amend the provisions relating to fundamental rights, and adopted the doctrine of prospective overruling to save the amendments that had been made hitherto. However, the basis upon which the conclusion arrived at and the reason thereof was the subject matter of several academic discussions, and Professor Blackshield, an Australian academician, was severely critical of the approach made by the court and indicated that there should have been more fundamental approach to the consideration of the scope of amendments that can be made to the Constitution. Inasmuch as the court had held that amendment to the Constitution is also a law falling within the scope of Article 30, and that Article 368 does not empower the Parliament to amend the Constitution, but it only provides for a procedure, fresh amendments were made to these two provisions. Firstly, by specifically excluding a constitutional amendment within the scope of law falling to be considered under Article 30, and marginal heading of Article 368 was altered from procedure to power of amendment. These amendments, along with 24th and 25th Constitution amendments, were challenged in Keshwanand Bharati versus State of Kerala. In that decision, Supreme Court held the power to amend the Constitution is available in Article 368. It noticed that the distinction between ordinary law and constitutional law and a constitutional amendment does not fall within the scope of Article 30. Amendment covered by Article 368 will extend to all provisions of the Constitution, but subject to the limitation of keeping these amendments within the basic features of the Constitution. This is what I need to explain, what is meant by basic features, how it is developed. The expression amend has restrictive connotation and does not extend to basic change, or in other words, there are inherent or implied limitations. It was noticed that by several judges who constituted the majority that the supremacy of the courts, democracy, secular character, separation of powers, federal character and rule of law were certain aspects of the basic features of the Constitution. In a Constitution running to 395 articles, 12 schedules and 3 appendices, it is difficult to perceive that Constitution makers would not have spelt out the scope of amendment but left the same to be implied in the Constitution or to be inferred by necessary implication. Further, even such an important power is inherent in the Constitution could also have been spelt out specifically, as they do it in several enactments. They have done it. For example, in the Civil Procedure Code, Section 151 is enacted to save the inherent power of the court. Such a provision has not been made. Therefore, several authors have criticized this line of reasoning of the Supreme Court. On the other hand, a different approach is made to understand the basic feature or the basic structure of the Constitution. To understand the scope of amendment, as envisaged in Article 368, must understand the architecture of the Constitution and thereafter attempt an interpretation on structural basis. There may be several methods of interpretation in support of legitimacy of the interpretation placed by the Supreme Court. The best course would be to adopt the structural interpretation as a justification of the basic structure of the doctrine. The several authors like Professor Sate, Robin Elliott, a Canadian professor, and others are of the view that structural interpretation features the Constitution in totality, accounting for its philosophy and spirit. The implications in the basic structure are provisional in character. Whatever implication arises thereto, the constitutional document has to be interpreted in its totality so that the integrity of the document is maintained. Further, the said implications allowed the court to reconcile the various provisions which apparently conflicted with each other in a principled fashion. Analyzing the structural interpretation of the Canadian Supreme Court, Professor Robin Elliott advances structural argument as a form that proceeds by way of drawing implications from the structures of the government created by the Constitution and the application of the principles generated by those implications made to the particular constitutional issue at hand. The principles so generated are not simply aids to interpretation, but is equivalent to the text of the Constitution itself. Thereby, the preamble to the Constitution, which is the philosophy of the Constitution, and many of the rights which got a fundamental nature or a character contained in Chapter 3 of the Constitution, or any other provisions like those pertaining to the independence of judiciary or provisions relating to democracy, could all be taken note of. If some of these principles are taken away from the Constitution, the core of the Constitution will be lost and Constitution will be reduced to cipher. The kind of amendment to the Constitution cannot be provided at all. If I may elaborate, can we think of a Constitution without the concept of democracy or rule of law? Can we think of it? If these are the basic features or basic structure of the Constitution, these are not mere aids, this is part of the Constitution itself. Then if this core is lost, then what would be left in the Constitution? That is the interpretation placed by the Supreme Court. It has to be understood in this manner. You may notice that in the earlier cases, all these cases, including the Keshwananda Bharati's case, the basis is this: they all dealt with rights to property. None of these cases dealt with any right relating to democracy. None of these things related to electoral rights. The first case that really came up before Supreme Court, which gave a challenge in relation to the democratic rights, was Mrs. Gandhi versus Rajendra. That was the case in which this aspect was dealt with. The decision in Keshwananda Bharati that as to basic structure acquired legitimacy by specific evidence eroding democratic values such as emergency and the 39th Amendment to the Constitution, which wanted to overrule the decision of a court and uphold election of Mrs. Gandhi. and certain consequential amendments. The decision Indira Gandhi versus Rajendra showed the futility of theories of parliamentary supremacy in the face of hard reality. Courts normally are not affected by arguments in terrorem and hold the possible abuse of power is not the test of its existence. Here and there was a case of naked abuse of power manifesting itself in the form of amendment to the Constitution solely to keep an individual in vast power by a plain majority while members of the opposition were in jail. Basic structure doctrine, characterized as anti-democratic, was used to prevent the murder of democracy. That judgment was a unanimous judgment rendered by 5 judges, of whom 4 did not subscribe to the basic structure theory while sitting in deciding Keshwananda Bharati's case. Nevertheless, all of them relied upon the basic structure doctrine as laid down in Keshwananda Bharati, and they invariably relied on various grounds such as freedom, democracy, equality, and rule of law, being parts of the basic structure of the Constitution. Thereafter, and in post-emergency phase, the basic structure of the doctrine has been consolidated and has stood the test of time for nearly 37 years. The view expressed in Keshwananda Bharati has not been altered thereafter. The view in Keshwananda Bharati was reaffirmed in Minerva Mills case, in Vaman Rao's case, in Koila versus State of Tamil Nadu, and several other cases dealt with by the Supreme Court. Sometimes not necessarily requiring the application of the doctrine of basic structure. It would have been imprudent for application of the same in respect of examination of validity of the executive orders or validity of a statute not affecting the Constitution. They could be dealt with by merely examining on the touchstone of constitutional validity and not necessarily on the high principle such as the basic features of the Constitution referred to in the context to the amendment of the Constitution. I may illustrate it with reference to 1 or 2 decisions where the Supreme Court has erred or aberrated itself. One instance is the case relating to the Constitution of Administrative Tribunals and the powers thereof. A judgment given by an administrative tribunal is subject to writ jurisdiction of the court. That may save the independence of the judiciary, that may be all right. But to the extent it says that it should be heard by 2 judges of the High Court, I do not know which principle of law will be required to state that, which basic structure of the Constitution is affected thereby. Or in the matter of saying that the Chief Justice should have the primacy in the matter of appointment or transfer of judges, the primacy of Chief Justice is to be saved by the expression of opinion of 2 of his colleagues or 5 of his colleagues, 4 of his colleagues. That kind of an approach is totally uncalled for. In order to maintain the independence of the judiciary, this approach was not required at all. Anyway, this was adopted in those cases. The basic feature must be understood to be a high principle relating to the interpretation of the Constitution with reference to a constitutional amendment, and it should not be lightly used in respect to the ordinary enactments or exercise of executive power. That should never be applied. If we use that, if the court lays down the principle, the policy will be laid down by the legislature. This is the harmony with which both the Parliament and the Supreme Court can function. If that is understood appropriately, I think where there be proper regulation of the powers. The restraint, so far as Supreme Court is necessary, has got to be applied. Restraint, so far as Parliament is necessary, has got to be applied. If these 2 things are applied, then certainly democracy can function very well. The politics, the next case I will deal with is with reference to politics of defection, which is the bane to the parliamentary system. The voice of defection has been rampant in India for quite some time, especially in the state level. You have heard of the state of Haryana where there were IRAMs and GAIRAMs. In fact, we had a Chief Justice in our High Court who came from Haryana, state of Punjab and Haryana, who used to say, I can deal with any judge in your court because I come from the state of Bansilal, Devilal and Bhajanlal. He used to say that. If I can deal with them, I can certainly deal with anybody. This is how he used to say. This is the approach. By defection, I mean floor crossing by a member from one political party to another. Defection causes government instability, is undemocratic, and it negates the electoral verdict. A party which fails to get majority in the House through election may still be able to maneuver majority in the House and form government by inducing defection from other parties. Thus, the party which may have won the majority may fail to form the government because a few of its members defect from the party. There are two kinds of floor crossing. Member may change his political party out of conviction because he may consciously disagree with the policies of the party to which he belongs. If he leaves the party with whose support he is elected, ought to resign his seat and seek fresh election. Such member defections are rare. The other class of defections take place out of selfish motives, as the defectors hope to order appointed as ministers or get some official position which they do not get. In 1997, Kalyan Singh formed a government with the support of defectors from Congress and BSP. Almost all defectors were appointed as ministers and the size of cabinet was 97. To contain this evil of political defection, Constitution 52nd Amendment made modifications to several articles and introduced a schedule, 10th schedule. A person disqualified under 10th schedule becomes disqualified to be a member of the House. There are restrictions on the number of members to be in the cabinet, being 15% in terms of Article 71(5)(1) capital A and 164(1) capital A. The constitutionality of anti-defection law has been upheld by the Supreme Court in a 3-2 decision in Quixota Holohan versus Zarchelu. At the same time, the court ruled that the Speaker's order under law disqualifying the members of the legislature on the ground of defection is subject to judicial review. The majority view is that main provisions of 10th schedule are indeed to provide remedy for evil of unprincipled and unethical political defection. However, para 7, which excluded Speaker's decision from judicial review, had not been ratified by one half of the number of state legislatures in accordance with Article 368(2) of the Constitution, and as such it was held to be invalid. Other portions of the constitutional amendment, being independent of and could stand apart from the other provisions of the 10th schedule, was held to be severable from para 7 as they were complete, workable and not truncated as a result of invalidation of para 7. The court held that the majority of provisions of relating to defection, disqualification and defection did not violate any rights of freedom guaranteed to the legislature in Article 105 and 194 of the Constitution. But so far as the minority is concerned, it did not agree that Schedule 10 could stand in the absence of para 7, which excluded the jurisdiction of the judicial review, and therefore they could not agree with the majority. But they expressed also a doubt as to whether the Speaker can play the role of sole arbitrator in the defection cases, and it would be appropriate that an independent adjudicator machinery should be set up for resolving the disputes relating to competence of the members of the House. The majority took a view that the Speaker, when he decides the question of disqualification of a member of the legislature under 10th schedule, acts as a statutory authority, in which capacity his decision is subject to judicial review by courts. The provisions had been made earlier in the 10th schedule, have been amended subsequently by doing away with a distinction between split up in the party and defection as such. However, speakers who have been elected by majority of the House have not always acted independently, nor have they taken timely action. Therefore, it is still reasonable to expect the Union Legislature to amend the Constitution to make Election Commission or some other authority to decide the questions of defection. Another aspect that needs to be examined is as to the justiciability of proclamation issued under Article 356. Till the decision in Bommai versus Union of India, attempts made to bring the matter of proclamation and Article 356 before the court for scrutiny had not succeeded. The 1989 Janata Dal ministry, headed by Bommai, was in office in Karnataka. A number of members defected from the party, and there arose a question as to whether his ministry enjoyed majority support in the House. The Chief Minister proposed to the government that an assembly session can be called to test the strength of the ministry on the floor of the House, but the governor did not explore the possibility of an alternative government, but reiterated to the President that Sri Bommai had lost majority support in the House, and as no other party was in a position to form the government, action can be taken for accordingly, the President issued proclamation in April 1989, Similarly, proclamations has been issued in respect of states of Meghalaya and Nagaland. They were also under challenge. Besides these, 3 more proclamations before the Supreme Court made in respect of governments in Madhya Pradesh, Himachal Pradesh and Rajasthan in 1992 in the wake of demolition of disputed Babri Masjid structure in Ayodhya. The government in these states belonged to BJP, which by their inaction was responsible for the public unrest in the wake of demolition of the masjid. By the Bommai's case came before Supreme Court, Article 356(5) putting a ban on judicial review on the issue of proclamation had been repealed. The Supreme Court by majority decision declared that Karnataka, Meghalaya and Nagaland proclamations as unconstitutional, but proclamations in respect of Madhya Pradesh, Rajasthan and Himachal Pradesh were held to be valid. The bench of 9 judges rendered 7 opinions. Justice Ahmadi and Ramsamy adopted a passive attitude towards judicial review of judicial proclamation under the Article 356, while others adopted somewhat activist stance. However, several propositions can be enunciated as being the consensus among the judges. The validity of proclamation issued under Article 356 is held to be justiciable on the grounds such as whether it was issued on the basis of the material at all, or whether the material was relevant enough, or malified exercise of power, or absence of relevant grounds. The question whether the Chief Minister had lost his majority in the Assembly has to be decided on the floor of the House and not by the Governor in his office, and also had a duty to explore the possibility of forming an alternative ministry in the event the ministry loses support in the House. The proclamations had to be approved within 2 months by both Houses of Parliament, otherwise it automatically lapses, which means that the President ought not to take any irreversible action, such as dissolution of the Houses, till the proclamation is approved by the Parliament. But on the issue of proclamation, such House can be kept under animated suspension for a period not more than 6 months. Once the proclamation is approved by the Parliament, the same lapses at the end of 6 months or is revoked earlier. Neither dismissed state government nor dissolved state legislature will revive. If the court invalidates the proclamation, even if approved by the Parliament, the action of the President becomes invalid. The state government which was dismissed will revive, and the state assembly dissolved will be restored. The power under Article 74(2) does not come in the way of calling upon the government to disclose the material upon the President had formulated the requisite satisfaction. Several other aspects have been dealt with, and the court laid an emphasis on secularism, which is part of the basic feature of the Constitution. Therefore, if a government is not carried on in accordance with the constitutional provisions, Union government can hold such a circumstance as breakdown of the constitutional machinery. Caution was struck that as federalism has been regarded as a basic value of Constitution, interference with an elected state assembly by the central government is really a negation of the federal concept, and wrong exercise of such power can damage the federal fabric and disturb the balance. Till Bommai's case was rendered, the power under Article 356 had been used on more than 90 occasions, and in almost all cases, opposition political parties were in power in the state. If a state government acts contrary to secular concept, Union government can lawfully rely on such reason. The government cannot be carried on in accordance with the Constitution. The state government may enjoy support in the Assembly, but is subject to observance of secularism, and it can be dismissed under Article 356(1). Subsequent to Bommai's case, it has become extremely difficult to invoke Article 356. On October 21st, 1997, the Chief Minister of Uttar Pradesh could not obtain a vote of confidence amidst pandemonium in the House of. Therefore, Governor made a report recommending imposition of President's rule in the state, and central government recommended for invocation of Article 356, but the President returned the recommendation for reconsideration by the Cabinet. Particularly when the Chief Minister had seemingly won the vote of confidence in the House, the Governor's view as to break down the constitutional machinery was of doubtful validity. Again, in 1998, central government recommended to the President for invocation of Article 356 in the state of Bihar. The main allegation against the government was worsening of law and order situation in the state. But the state government enjoyed majority in the Assembly. The President was of the view that acts complained should be of breakdown of the constitutional machinery in the state, to use Article 356. But he made a distinction between the bad governance and breakdown of constitutional machinery in terms of the decision in Bommai's case. These decisions advanced the step to strengthen democracy in the country. Except for the imaginative interpretation given to the various provisions of the Constitution, such result could not be achieved by the Supreme Court. I have chosen a topic on the performance of an institution of which I was part of, and its impact on the Indian democracy of which I am a citizen. I have dealt with this topic in the evolution of Supreme Court in different phases of the first decade, second decade, during the 5 years prior to the emergency, its role during emergency, and thereafter. I have summarized these various periods with reference to broad aspects dealt with by the Supreme Court and the impact of several decisions on democracy. In particular, academicians and other legal writers are strongly of the view that the judicial activism and judicial review of amendments to Constitution by relying on basic structure theory and the interference with political decisions such as the imposition of President's rule and assumption of powers in the matter of appointment of judges are all anti-democratic and do not promote democracy. The Supreme Court plays a pivotal role in the Indian political economy in a society which is fractured and polarized on communal lines where ideology has disappeared. Despite occasional failures and not measuring up to expectation of various sections, Supreme Court has become an institution on whose legitimacy there seems to be a national consensus. Maybe it is despised by environmental activists or developmental activists or by Hindu militants for its secular stand or by educationists for privatization stand on education, by secularists for its soft Hindutva stand, and by the leftists for its decision not to intervene in the government decisions to disinvestments in public sector units. There are several institutional limitations, but all sections have approached it for adjudication for their social, political, and religious disputes. Judges also have shown several limitations while dealing with the complex social issues. At times they have been legalistic and populistic in approach. The court has been required more and more to engage itself in political issues as to whether a person could continue to be a minister after exhausting 6 months after being elected to the legislature, or whether election commission was bound to hold elections to the legislature within a period of 6 months of its dissolution. There are issues of whether the court overused its powers, of contempt of court, of parliamentary supremacy, and the limits of judicial activism. I have demonstrated the various aspects of by reference to some of the decisions of the court which have become controversial or have contributed to the strengthening of rule of law and democracy. I have also referred to decisions in which court has failed to measure up to the people's expectations. There has been vacillation between hope and disappointment, but ultimately hope has survived. The court is indeed the forum for legitimizing the establishment as well as dissent. There is a general feeling, whatever the failures and disappointments, the court has inspired anti-establishment force to seek its interventions in defense of democracy and the rule of law, and thus the court remains the main bulwark of Indian democracy because other organs of the state have not shown any promise of rejuvenation. Judicial review of administrative action does not extend to determine whether a particular policy or decision is wise or fair. In the second part of the last decade, new significant phenomenon emerged, which has a momentous dimension and disturbing in impact by exposures of sordid events in media, both print and electronic. The movement has been for right to information, the call for open government, the demand for accountability of public functionaries, and for transparency in their activities. Together with the temptation for the sensational media, aggravated the situation and brought the issue of corruption to intense focus. In the past, the law provided source of authority for democracy. Now the law seems to be replaced by public opinion as a source of authority, and the media served the purpose. The religious and caste conflicts, the street crimes, the corruption, the pollution, the poverty, the social aberration has intensified uneasiness amongst Indians. The people started deeper cause for alarm was the deterioration in civic values, a loss of confidence in the future, and sense of failure to control the events, with growing feeling that quality of life was declining. People in power did not respond to the same, but Supreme Court did. Instances of corruption arose in the background of economic political liberalization, the emergence of regional elites, market-oriented model development, altered value system with the growing tax havens and offshore financial centers aggravated the temptation to be corrupt. The sugar scandal, security scandal, Hawala transactions, veterinary and animal scandal, JMM bribery case, urea scandal, communication department scandal, house king scandal, petrol pumps and LP scandal, uniform and medicine purchase scandal, Patak's bribe case, Indian Bank noticed corruption in all facets of public life. Modality that court adopted in corruption case is that first notices will be issued to the person in authority to show cause. At the failed or played truant, the court cracked the whip and threatened with a contempt power. I have explained the process adopted by the court in dealing with those matters. The Supreme Court having entered the 60th year and the world entering the third millennium, India will commence a new beginning. It will privatize by disinvestments of its equity in public sector undertakings, which are once commanding height of Indian economy. Urban India will henceforth be dominated by a new generation obsessed with computer, email, internet, and living in pizza culture. A new lifestyle demanding quick beneficial results will assert whatever be the impact of local or global terrorism. Where, when, how fast, and to what extent, and in what degree process will expand depends upon limits of the possible and the ambiguity of the events. This now emerging socio-economic scenario will be the context of the future Supreme Court to operate. Thank you very much for your patient hearing. Yes, all right. I have not. I can start. No problem. More convenient answer.
Shall I ask one question?
Yes, please.
We will have questions and answers.
Only on the subject on which I have spoken. Please don't extend it to further things.
Diamond again.
Don't divert the attention. You can speak. You can ask questions. Please ask precise questions.
All right.
He will answer.
All right.
Time and again, the government at the center has been.
And you see, this idea was mooted even earlier when Chief Justice Bhagwati was in power. Again, this idea to decentralize the Supreme Court into two courts, one a court of appeal, another a constitutional court, was thought of, but it did not go through. I don't think that anything such thing will happen.
You have already referred to the lecture about the RTA Act.
Huh?
RTA Act.
Yes, sir. I will express my view. To decide. If you decide that there should be a qualification, there will be a qualification. You decide there should not be any qualification, there need not be. Yes. Sure.
So, in the sense, we can say like the Constitution. So it has
One third of the members join the other party. One third of the members join the one group. If they take away, then it is as good as split in the party. That idea is gone now. If the whole of the majority, 2/3, if they go there and join another party, where was the difficulty? You see, you please remember, when Sharad Pawar was in power in Maharashtra, at one time, you see, he belonged to Janata Party. Then he joined Congress Party, wholesale. All the members of the legislature, they joined. See, that such things have happened. Bhajan Lal did it in Haryana. See, this kind of exercise itself is unprincipled. That should be avoided, but anyway, it happens. In fact, the criticism in the court was that the conscience of the particular member should be respected. If he is being elected from a constituency, once he is elected to the parliament, thereafter it is left to him to exercise his conscience in any manner he likes. He need not go back to the constituency. That was how it was put. But that was all overcome by the court in a very, it's intellectual judgment. This has been explained, and though the minority did not agree with it, this particular legislation has been upheld. In fact, the fear was, if that legislation is struck down, there may never be an occasion for that to come back, because it was during Rajiv Gandhi's time this law was brought. He had an absolute majority, a brute majority in the parliament. So he could push through the amendment. Whereas if any other party like the present ones, the all coalition governments, weak governments are there, they may not be in a position to push through such a legislation. They will never do it. To do with it, I won't answer you. See, what happened was in Shabana's case, Muslim Marriage Dissolution Act, you see, that was brought into force. Thereby, they said that this kind of, law that was made or declared by Supreme Court in Shabana's case was sought to be nullified by that law. Thereafter, in Daniel Latifi's case, the Supreme Court explained the scope of that amendment, that the law that was brought into force, that law will not nullify the law, it has misfired the objective, and on the other hand, it further develops the particular ideas that have been stated in Shabano's case. It strengthens those views. It reiterates those views. That was what I said. In fact, commenting on that, Justice Chinnappa Reddy, in his book on Constitution, he says that it is a very audacious, daring, but a bold and brilliant judgment, he says. Talking to the nation as such, the role of the Supreme Court as an institution in a democracy, how it should be, that is what I am focusing. I don't want these individual problems. Please ignore it. It is come. See, if there is corruption, if there is want to hide something, it is bad. It should not be there. See, once life, when you are in public life, it should be open. Now, that's a different aspect. That kind of a thing can be done. Don't bring in Shailendra Kumar, who is here. Don't embarrass him or embarrass me. And cabinet secretaries among them. A few of them were cabinet secretaries. They brought a petition before the court. They said that for good governance of the country, Supreme Court should examine each one of the aspects that have been mentioned in the 3 schedules to the Constitution. Then what will Supreme Court do? Even if every single judge of Supreme Court sit for that particular matter, it will not be possible to deal with all the matters. No, it will be impossible. When specific cases come up, courts can deal with. Otherwise, it will not be possible. See, many times there are failures. We cannot say the best form of government is the one which rules the best, not necessarily. See, what happens when democracy is there, when you elect the government, that is the best form of government.
Sir, Prime Minister can increase the number of ministers in his cabinet, but like that, Chief Justice can increase the number of...
That's all right. No, so such power is there. It's not possible. On the other hand, Constitution prohibits it. Yes. All right. I don't know.
Last point, sir.
Yes.
Mr. Dinkar case.
Please don't ask individual cases. I told you about it.
Friends, you have been listening to Justice Rajendra Babu elucidating all the finer points concerning judiciary, parliament, and also executive. It's more than an hour. He has been able to bring about all the finer elements in those matters. How Parliament is able to function, how Supreme Court also is able to function at the same time. Now we are having democracy, and the Constitution has provided us how this democracy, our democracy, will have to work. Of course, there are certain differences between types of democracy in the sense, republic democracy as in vogue in America is different because there it is presidential type of democracy. Of course, here we are having parliamentary type of democracy where parliament for all purposes is supreme. That has to be interpreted or declared by the Constitution whenever a crisis arises. Otherwise, the scope of Supreme Court is in interpreting the laws passed by the Supreme Court, passed by the Parliament, will always be confining itself to that. Such being the case, you cannot say who is supreme and who is not supreme. See, Parliament, as in England, it is said, it is Parliament can do anything except changing the sex of a person. So that seems to be the criteria found in England. So these are the 2 types of democracies which we have been able to follow, and our constitutional fathers were able to concentrate good points on both the states, and have been able to evolve this constitution. And we also know from the last 60 years, we are carrying on with this constitution. And I must say, it's really a commendable thing. Because round about our country, number of countries, we started with parliaments, have given end to that, and have become dictator-oriented places. Fortunately, in our country, with all the defects or whatever it may be, we are still adhering to the principles of constitution and the democratic principles also. We all know that there are black sheep in every section of the society. Of course, people elected to the parliament come from the society. Judges who are appointed from the Supreme Court and other courts also come from the society. Society being what it is today, we have got all the defects and we also got the fine points also. But we have to accept things as they are. There will have to be a finality at some stage. See, why do we say that Supreme Court's judgments are final? Because there is no other authority which can entertain cases against the Supreme Court. Such being the case, the judgments of the Supreme Court becomes final. In that way, even though there are certain defects, you see, at the time of recruitment and even afterwards, the society has to correct it slowly and continuously. It has to be done. I know today, even in judiciary, there are some credibility questions. Of course, regarding our elected representatives, we all know what is the state of parliament today, whether it is parliament or whether it is state legislatures. It's really, I should say, I happen to be secretary for this legislature here for about 5 years. I could see how day by day, year by year, the type of what shall I say, the representatives coming before the assemblies are deteriorating. It only represents the society. If we are able to correct that, then only we could say with definite voice that they should not do like this. But unfortunately, what is happening, we elect them, and when once they are elected, they know how they are getting, we know how they are getting on. Maybe time will only come to our rescue, and after some time, the type of legislators we are going to have may be different. That has to be seen. Because today, the electorate appears to be particularly comparatively younger people. If they make up their mind and elect proper representatives, our hope will be sustained. Otherwise, we have to continue like this for some more time. That appears to be the position today. I am very happy today, Dr. Rajendra Babu has been able to elucidate all the points pertaining to Constitution of India and also the place of Supreme Court and it. He happened to be the judge of the highest order, and he had the personal experience of all those judgments. And he has been able to explain it to us in such a scintillating fashion. I am really grateful for his erudite speech. The only reason why I have been made to be the president of today's lecture is I happen to be a colleague of his father. That was my proud privilege. See, a few years I spent my time with him, both in secretariat and also in the courts. And I have always and I always carry the sweetest memories of his association with me. And it is so nice of him to speak so about me. I must thank you all for having given a patient listening. I don't want to elucidate any other matter because he has been able to do it in such an academic and brilliant way, and I don't want to take further. I thank the authorities because I happen to be one of the members of the executive committee of the Gokhale Institute, and that's another reason why I could come here and preside over the function. And today we are really feeling the absence of Mr. Ramaswamy. If he only was here, I am sure he would have enlightened you with some of those questions also. We miss him. I thank once again the speaker and also Justice Puttaswamy for having given me the opportunity to come and preside over this function and speak only a few words about it. Thank you all. Thank you.
I have been asked to deliver the welcome speech as also the vote of thanks. That is how I am standing before you on both the occasions. Mr. S.R. Ramaswamy, he had suggested, I think, democracy and law, as I remember, as the subject to be spoken to by Mr. Rajendra Babu. He wanted me to go and contact Mr. Rajendra Babu along with Mr. Ramu, who is standing before us, And I went, both of us met Mr. Rajendra Babu at his residence, requested him to deliver a lecture on democracy and law. He told, it is such a vast subject, it is impossible for anybody to cover that too within 1 hour or 1.5 hours. Then he said, both of us agreed, you choose the subject, we will agree for that. Then he chose the subject, and I am extremely happy that he has given a scintillating exposition on the democracy, working of the democracy, and the development of democracy, particularly S.R. Bommai's case, which is now holds the field and has put a check on the arbitrary exercise of power by the central government. Because at the time Bommai's case was argued before the Karnataka High Court, I was present before the Karnataka High Court before Justice Narayan Pai and another judge.
Bommai's case was heard by...
No, it was dismissed here. It was dismissed here by the Karnataka High Court. Then it was taken in appeal, as Mr. Babu has pointed out, the various developments. Now, I am happy that S.R. Bommai's case has put a check on the power of the central government to dismiss the state governments as and when it pleases. Probably you may remember the present governor of Tamil Nadu did not recommend for the dissolution of a DMK government or so. Therefore, it is checked the various facets of democracy, how it has developed, and particularly Bommai's case has been placed before you. Democracy ultimately, friends, I must confess, it is the intellectuals that have failed. Probably in Bombay, I have seen, very wealthy city, the percentage of voting is only 30 to 35%. You must remember, people get the government they deserve. If you and I don't go and exercise our power, what is it you can? Now there is also a provision, we can say, it has been pointed out, none of us, there is a provision in there. Of course, Mr. Babu mentioned about one of the cases before the Supreme Court that was filed by one Chaukar of Ahmedabad Institute, Ahmedabad IIM. He happens to be a member of the Indian Liberal Group, and it was he that filed that case, and it gave us a trendsetter before the Supreme Court. So far as why, I can't add anything more than what has been said by Mr. Babu and Mr. T. Venkateswamy. It so happens he is a good friend of mine, and when the question arose, who should preside over the function, I I persisted that Mr. T. Venkateswamy should preside over the big function because he has such a knowledge of the working of the council. I asked him now when I was sitting in the room, you must have read in the Andhra Pradesh secretary has made about 25 to 50 to 30 crores. I asked him, where is the chance for a secretary to, then he gave me the explanation. It appears in allotment of houses, everything, other things he has for. I never imagined that a secretary of the legislature can be corrupt. That was my understanding, poor understanding of
It is the greediness that makes one
Huh? That was my poor understanding. Lastly, friends, I will close my vote of thanks. In the Newsweek, an international edition of the latest edition, there is a very interesting article by one Jason Wardrow from worst to near first. That is, he visited Bihar. How Nitish Kumar, known for his absolute honesty, he is a teetotaler, he has changed the face of Bihar within 2 or 3 years. Of course, he also says whether he will be elected next time is a debate. But how one man can change. He has also referred to Naveen Patnaik and Narendra Modi, whom we consider as a demon, because many of us consider, particularly Englishmen, but he has referred to all these three persons. How one person can change, because they don't allow their relatives to come and influence them. They don't appoint their relatives to any of their posts. They keep them off. And how, of course, I deliver this copy because whenever I complete it, I deliver the copies to the Gokhale Institute of Public Affairs for reading room. Any of you who are interested in this article may kindly read it and benefit it from how one man can change the entire. Therefore, ultimately, it is the personality that counts. As I said, people get the government they deserve. Therefore, if democracy has sustained so far, it has sustained by what is called as the dumb and mute voter rather than the intellectuals. I have never failed to exercise my vote. Even when I was a judge of the Karnataka High Court, I went and exercised my vote. Because some of the judges were of the view, judges should not take. All right, it is your opinion, my opinion is different. I go and vote, I voted. Therefore, you choose the right persons. If you choose the right persons, and if the right government is there, certainly many of our problems can be saved. And what Dr. Ambedkar said in his concluding remark, he said, on 26 January 1950, we will have a democratic republican constitution. We will have political democracy. But economic and social democracy, you will not have it. Unless you remove this contradiction as early as possible, democracy will not be saved. I do not know whether they have been removed. It is for you to judge. With these few words, I express my sincere thanks to both the Rajendra Babu and Mr. T. Venkateswamy who are here today. Thank you, friends.